New Airport Rules 2026, CBP 5-year social media check. Big warning, the gate agent scans your boarding pass and smiles. Your luggage is checked. Your seat is confirmed. Your visa is valid. Your passport is stamped. And then the secondary inspection door opens. A Customs and Border Protection officer steps forward with a tablet in hand, a quiet expression on their face, and a question that most travelers never saw coming. We're going to need to review your social media accounts. All of them, going back 5 years. This moment didn't unfold over a long investigation. It unfolded in under 7 minutes. 7 minutes that could cancel a visa on the spot. 7 minutes that could result in a refusal of admission at the border. 7 minutes that could trigger a permanent bar from re-entering the United States. One post, one comment, one follow, one liked page from 4 years ago, and everything you built, everything you applied for, everything you waited years to receive, gone before you collect your luggage from baggage claim. What the new CBP social media review protocol represents crossed a line that civil liberties organizations had warned about for years. And when that line became official policy, CBP did not ease into it. They moved with authority, with technological infrastructure, and with a level of reach that extends years into your digital past. Most travelers panic at secondary inspection. They hand over their phones. They open their accounts. They assume that showing everything will prove they have nothing to hide. That is the trap. But today, you are going to understand exactly what CBP is looking for, exactly what triggers the 5-year review, and exactly how to protect yourself before you ever reach the inspection door. For several years now, there had been signals, not from official CBP press releases, not from formal congressional testimony, just signals, that the agency was developing something far more expansive than the social media screening that had already been introduced on visa applications. CBP had been systematic in its approach, yes, but also patient in building the infrastructure that would make large-scale digital review possible at ports of entry. Their development followed a pattern, a quiet expansion of legal authority, a period of technology testing, almost a deliberate normalization. But what began alarming immigration attorneys and digital rights organizations in late 2025 was that the testing phase suddenly stopped being referred to as a test. It became standard operating procedure. Travel and immigration legal networks who monitor CBP policy changes recognize the indicators. The expansion of the social media identifier field on ESTA applications and visa forms to include not just usernames but full platform lists. The procurement of AI-assisted content analysis software by the Department of Homeland Security. The quiet modification of CBP officer training materials to include digital review protocols as a primary inspection tool rather than a secondary one. And the sudden absence of any public timeline or limitation on how far back social media content could be reviewed. When a government agency stops talking about the boundaries of what it's doing, it has already decided those boundaries don't apply. Early in 2026, immigration legal organizations began documenting what they described as a dramatic escalation in digital screening at major U.S. airports and border crossings, including the routine review of social media content going back 5 years, not seen at this scale or with this level of institutional formalization in the history of U.S. border enforcement. These are tools CBP only deploys when pursuing something specific. A systematic effort to identify individuals whose public statements contradict what they declared on their visa applications. A strategy of detecting ideological patterns that enforcement agencies consider relevant to admissibility determinations. Or a broad data collection initiative designed to build behavioral profiles of foreign nationals entering the United States over time. Legal observers weren't certain which of these objectives was primary, or whether all three were operating under the same program simultaneously. But one thing became undeniable. CBP's posture toward digital identity had changed completely. And when that happens without clear public guidelines about what triggers a review, every international traveler needs to understand what the system is looking for before they board. The warning issued by immigration attorneys and civil liberties organizations in 2026 was not routine. It was not a general privacy reminder. It was urgent and targeted. Attorney after attorney described the new social media review framework as invasive, legally ambiguous, and most importantly, consequential in ways that travelers do not anticipate because the content being flagged is not always what they expect. It is not only extremist content that triggers action. It is not only explicit statements of intent. It is associations. It is affiliations. It is the accounts you followed, the posts you shared, the comments you made on someone else's content during a period of political tension in your home country. And the most dangerous part of this system is not what it finds. It is that travelers hand it everything voluntarily because they do not know they have a choice. The response from informed legal communities was among the most urgent mobilizations seen in immigration rights advocacy in recent years. Here is what CBP's own public documentation, legal filings, and immigration attorney case records confirmed. CBP officers conducting social media reviews at ports of entry are not conducting random checks. They are targeting travelers who have been flagged through pre-travel screening systems. They target individuals whose visa applications included social media usernames that were then cross-referenced with AI content analysis tools before the traveler even boarded their flight. They target passengers whose travel patterns, national origin, or prior inspection history places them in categories that CBP's risk assessment algorithms have already scored. They target content that mentions political organizations, religious groups, geographic locations connected to areas of national security concern, or statements that could be interpreted as inconsistent with the purpose of travel declared on the visa application. This is not an inspection happening at the airport. This is an inspection that began the moment you submitted your visa application and is being completed at the gate. So let's talk about what the 5-year social media check actually looks for. Because understanding the target is the only way to understand the risk. CBP officers and the AI-assisted tools they are now using look for several specific categories of content. The first is direct contradiction of visa purpose. If you applied for a tourist visa and your social media shows posts about job searching in the United States, networking with American employers, or expressing a desire to remain in the country permanently, that is a contradiction. If you applied for a student visa and your social media shows activity inconsistent with enrollment, travel posts, work-related content, or extended stays in locations far from your stated university, that raises questions. If you applied as a business visitor and your social media documents activities that look more like employment than business meetings, that is a problem. These contradictions do not require an officer to make a judgment call. The AI system flags them. The officer acts on the flag. The second category is political and ideological content. This is the one that catches travelers by surprise. CBP has broad legal authority under the Immigration and Nationality Act to deny admission to individuals who have engaged in activity related to certain political or ideological categories, terrorism being the obvious one. But the list extends further than most people realize. Posts expressing support for organizations that the United States government designates or considers a foreign policy concern can be flagged. Comments made during periods of civil unrest in your home country, comments that felt ordinary in their context at the time, can appear very different when reviewed in isolation by an algorithm operating without that context. Shared content from accounts that CBP systems associate with flagged networks can create an association that the traveler never intended and cannot easily explain at a secondary inspection desk. You did not have to write the post. You only had to share it, like it, or follow the account that did. The third category is consistency of identity. One of the primary functions of the social media review is to verify that the person standing at the inspection desk is who they say they are and that their documented life online matches what they declared on their application. If your name is used differently across platforms, if your location history visible on public posts contradicts your stated address, if your relationship status, employment history, or family situation as shown through social media does not align with what was declared to immigration authorities, these are triggers. This is not necessarily about deception. It is about the appearance of inconsistency. And in a secondary inspection, appearance is what matters first. Now here is what you need to do before you travel. Not at the airport. Before you ever get on the plane. The first step is conducting a full audit of your own social media presence. Go back 5 years on every platform where your account has been active. Look at everything you posted, shared, liked, and commented on. Look at every account you followed and still follow. Look for anything that could be read in isolation, without context, by a system that does not know you as contradicting your visa purpose, associating you with a flagged organization, or suggesting a political position that conflicts with U.S. immigration admissibility standards. This is not about erasing your identity. It is about understanding what your digital presence looks like to someone who does not know you. The second step is reviewing your privacy settings. Many travelers do not realize that CBP's social media review is primarily focused on publicly visible content. Officers are not, at least not in standard protocol, hacking into private accounts, but they're conducting thorough reviews of everything that is publicly accessible. Tighten your privacy settings on every platform before you travel. Move past posts to friends only or private where possible. Review what is visible to the public on your profile page, your photo albums, your tagged content, and your followed accounts. This is a lawful protective measure. It is not deception. Public content is called public content because it is visible to anyone, including CBP. Private content is called private content because it isn't. The third step is understanding what you are and are not required to provide at a port of entry. This is where the situation becomes genuinely complex. CBP officers at a port of entry have broad authority. They can ask you to unlock your phone. They can ask for your social media usernames and passwords. They can ask you to log into accounts while they observe. You are not a U.S. citizen at a border crossing. If you are a foreign national seeking admission, the legal framework around your rights is different from what applies once you are inside the country. Refusing to provide access to your phone or social media accounts at a port of entry will not result in arrest. But it can, and in documented cases, it has resulted in denial of admission. For U.S. citizens, the situation is different. You cannot be denied re-entry to your own country, but your device can be detained and searched. For visa holders and green card holders returning from travel, the decision about whether to comply with a device search request is one you need to discuss with an immigration attorney before you travel, not after the officer is already holding your passport. Let's talk specifically about green card holders, lawful permanent residents, because there is a widespread belief that a green card protects you completely at re-entry. It does not protect you from secondary inspection. It does not protect your device from search. And it does not protect you from questions about social media content that an officer has already reviewed before you reach the desk. Green card holders can be found inadmissible under certain conditions. If you have been outside the United States for an extended period and your ties to the country have weakened in ways that show up on your social media, if your posts over the past year look like the life of someone who has relocated, not someone who has been traveling temporarily, that can be used to question whether you have abandoned your permanent residence. Know your own social media story before CBP reads it to you. Let's also address student visa holders specifically. If you're on an F-1 visa and you travel internationally, your return to the United States is not automatic. You need a valid visa stamp, a current I-20 with a valid travel signature and enrollment documentation. But in 2026, you also need to be aware that your social media presence during your time as a student will be reviewed in the context of whether it is consistent with being a full-time student. Frequent travel posts from exotic locations during the academic semester. Posts about earning money, building a business, or working in roles that appear inconsistent with student status. Public posts about frustration with your program, your institution, or your intention to remain in the United States after graduation, stated in a way that conflicts with the temporary purpose of your visa. All of these are flags in a 5-year social media review conducted by a system that does not have the benefit of knowing the full story of your life. Tell your story carefully, even when you think no one is watching. One more scenario that experienced immigration attorneys are raising urgently. What happens if CBP flags content and you are standing at the inspection desk in real time? This is not the moment to argue. This is not the moment to explain the context of a 4-year-old post. This is not the moment to demonstrate your knowledge of constitutional law to an officer who has broad discretionary authority at the border. If content is flagged and you are asked about it, you answer directly and briefly. You do not elaborate beyond what was asked. You do not volunteer additional information about other posts, other accounts, or other activities that were not raised. If you are placed in secondary inspection, you have the right to remain silent. You have the right to request contact with your country's consulate. If you are a U.S. person, a citizen, a green card holder, or someone with a pending legal matter, you have the right to contact an attorney. What you do not have is the ability to undo what is already visible online, which is why the time to act is before the flight, not after the flag. As 2026 continues and CBP's social media review infrastructure expands to more ports of entry and more traveler categories, more stories will emerge of visa holders, green card holders, and students who lost their admission, and sometimes their status, because of digital content they had forgotten existed. But one thing is already clear. Understanding this does not make you paranoid. It does not make you a criminal. It makes you prepared. It means you know what the system is looking for before the system looks for it in you. Audit your accounts before you travel. Review your privacy settings. Talk to an immigration attorney if you have any concern about your history online. Share this video with every international traveler you know. It might save a visa. It might save a green card. It might be the reason someone lands in the United States without incident on a day that could have gone completely differently. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of enforcement unfolds.